Have you ever pondered if one nation could legally confront another for inflicting environmental damage? Let me tell you, it's not just a query, but a real-life situation. This scene introduces the concept of countries suing each other for environmental harm, using an actual instance where Nicaragua took legal action against Colombia for environmental harm. This key dispute was centered around a river, a mutual waterway that served as a part of their shared boundary. Nicaragua put forth allegations that Colombia had been carrying out dredging operations, an activity that involves the extraction of sediment from the waterway's base, thereby causing considerable environmental harm within Nicaraguan jurisdiction. The implications of such destruction could be extensive, disrupting fragile ecosystems, negatively affecting fish populations, and even hampering the livelihoods of those who depended on the river. This scene navigates the nuanced role of the International Court of Justice, or ICJ, in environmental disputes, taking the Nicaragua vs. Colombia case as a prime example. The question at hand was, could the ICJ step in to resolve an environmental controversy between two nations? The response was a powerful affirmation. The court's choice to preside over the case highlighted a pivotal moment, emphasizing its potential part in tackling transboundary environmental harm. Following an elaborate examination of the presented evidence, the ICJ reached a conclusion. It held Colombia responsible for the environmental damage triggered by their dredging in the Mutual River. This was not just a triumph for Nicaragua, but it also sent a strong message about the gravity of environmental preservation globally. Even more, the court didn't limit its decision to merely laying blame. They commanded Colombia to undertake particular actions, encompassing steps to restore the environmental harm they had inflicted, and strategies to thwart analogous damage. This significant verdict set a precedent for proactive environmental management, pushing nations to assess potential risks and initiate preventive measures before environmental damage transpires. But what exactly does this term transboundary harm mean? This scene defines transboundary harm and discusses its implications. Simply put, it refers to situations where an activity in one country causes environmental damage in another. Imagine a factory releasing pollutants into a river that flows into a neighboring country, impacting their water supply and ecosystems. That, in essence, is harm in action. Using the Nicaragua v. Colombia case as an example serves as a stark reminder of our interconnected world, where actions in one country can have profound effects on another. It underscores the importance of international cooperation and legal frameworks in protecting our shared environment. And perhaps most importantly, it poses a question to all nations. What steps are you taking to prevent transboundary